All right, let's go ahead and get started. It's 9 o'clock.
Good morning, Your Honor.
Good morning. Mr. Nichols, if you would turn your camera on, please.
I'm so sorry.
That's okay. All right. We're on the record in 24 CPR 041936, the state of Don Victor Benskin. Mr. Nichols, if you would raise your right hand to be sworn by the court, do you solemnly swear or affirm that the testimony provided here today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Very good. Ms. Ballou, whenever you're ready, you may proceed with your proof.
Thank you, Your Honor. Would you state your name for the court, please?
Yes, my name is John Floyd Nichols, Jr.
You're the applicant in this case, and Don Victor Benskin was your stepfather. Is that correct?
Yes, ma'am.
Did he die on December 20th, 2023 at the age of 83 years?
Yes, ma'am.
And 4 years have not passed since between his date of death and the date that we filed this application, have they?
No, ma'am.
This court has jurisdiction because at the time of his death, Mr. Benskin had a fixed place of residence in Fort Bend County, Texas. Is that correct?
Yes, ma'am.
Did you look at the will before it? There we go. The court has done screen share on the will. Do you recognize that as the last will of Don Victor Benskin?
I do.
And there's his signature. You
Yes,
recognize that signature?
I do.
The will is dated October 16th, 1998. Was Mr. Benskin over the age of 18 years and of sound mind on that date?
He was.
And as far as you understand, the will is what we call self-proved.
Yes, ma'am.
And the will was never revoked, was it?
It was not.
The will names your mom, Jerry M. Benskin, to serve as independent executor without bond or other security. But Ms. Benskin filed a waiver and renunciation of right to serve as independent executor in favor of you. Is that correct?
Yes, ma'am.
And you were named in the will as an alternate independent executor.
That is correct.
There are some debts that need to be paid, so there's a necessity for an administration of this estate. Is that true?
Yes, ma'am.
No state, governmental agency, or charitable organization was named as a beneficiary in the will, were they?
No, ma'am.
No child was born or adopted by decedent after the date that the will was signed.
No, ma'am.
No marriage was dissolved after the will was made.
Correct.
Mr.
Yeah,
Benskin.
That's right. No, you're right. Yes.
Okay. I know it's backwards and it gets confusing.
Right.
Decedent did apply for and receive Medicaid benefits after March 1st, 2005. Is that correct?
That is correct.
And we contacted the Texas Medicaid Estate Recovery Program and received a certification back for them that there was no pending claim, nor were they planning to file a claim. Is that correct?
That is correct.
And that response has been filed with the court.
Yes, ma'am.
You are not disqualified by law from serving as independent executor. In other words, you've never been convicted of a felony, nor have you been convicted of a crime of moral turpitude.
No, ma'am.
And this is going to be a non-taxable estate, so we're asking the court to waive appraisers and asking that the court appoint you as independent executor to serve without bond or other security.
Yes, ma'am.
That's all I have, Your Honor.
All right, the court heard the testimony of John Floyd Nichols Jr. He testified as to the proof of death, validity of the will, and other facts. The court will admit the will into probate and appoint Mr. Nichols as independent executor to serve without bond, and appraisers will also be waived. Mr. Nichols, I'm very sorry for your loss.
Thank you, Judge. Have a blessed day, Your Honor.
You do the same. Ms. Ballou, anything further for the record?
Nothing further, Your Honor.
All right, y'all have a good day.
Thank you. I'll call you in a bit, Bo.
Okay.
Go ahead, Ben. Ms. Davila, is that your client with you?
Yes. Good morning, Your Honor. This
Good morning.
is Brian Medding, and my name is Denise Davila.
All right.
Good morning.
Good morning. All right, let's go ahead and get started. We're on the record in 24 CPR 041921, the state of Claudia Ann Medding. All those who intend to testify, if you'd raise your right hand to be sworn by the court. Do you solemnly swear or affirm that the testimony provided here today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Very good. All right, Ms. Davila, whenever you're ready, you may proceed.
Thank you, Your Honor. Can you please state your name for the record?
My name is James Brian Medding.
And Mr. Medding, how long did you know Claudia?
I knew Claudia for almost 50 years. We were married for about 47 years.
Thank you. And is it true that Claudia died on April 2nd, 2024 in Fort Bend County at the age of 71 years?
Yes, correct.
And that 4 years have not elapsed since the date of Claudia's death?
Correct.
And is it true that the court has jurisdiction and venue over the estate of Claudia because she had a fixed place of residence in Fort Bend County on the date of her death?
Yes.
And is it true that Claudia died testate and that her will was signed on November 6, 2009?
Yes.
And that the will was self-proved?
Yes.
And is it true that the will filed for probate was never revoked or modified by decedent?
Yes.
And the judge here has
Okay.
put a copy of the will. Do you recognize it?
Yes, I do.
Your Honor, can you please take judicial notice that the will was filed with the court? The original will was filed with the court.
The court shall take judicial notice.
Thank you. And is it true that you, James Brian Medding, were named under the will as independent executor to act independently without bond or security?
Yes.
And that no state governmental agency of the state or charitable organization is named by the will as a beneficiary?
Correct.
And is it true that after the date of the will, no child was born to or adopted by Claudia?
Correct.
And is it true that no marriage of Claudia was ever dissolved after the will was made?
Correct.
And that a necessity exists for the administration of the estate?
Yes.
And that you, James Brian Medding, are not disqualified by law from accepting letters testamentary?
Yes.
Thank you, Mr. Medding. That's it, Your Honor. Thank you.
All right. Court heard the testimony of James Brian Medding. He testified as to the proof of death, validity of the will, and other facts. The court will admit the will to probate and appoint Mr. Medding as independent executor to serve without bond, and appraisers will be waived. Mr. Medding, I'm very sorry for your loss.
Thank you very much.
Thank
Miss her a lot. It's been about 14 months now, so.
I have no doubt, and my condolences.
Yeah, thank you.
Thank you, Your Honor.
Ms. Davila, anything further for the record?
No further questions. That will be it.
Very good.
Thank you so much.
Okay, then.
Have a wonderful day.
You do the same. Let's bring in the attorney and see. Mrs. Bartlett, is your client with you?
I'm going to be the witness, Your Honor. I prepared the will and knew Mr. Hangy.
Okay. All right, we're on the record in 25 CPR 042468, estate of Walter T. Is it Hangy?
Hangy. He said Hangy. I think it's a
Okay.
Dutch word, but I don't know.
All right. All right. Well, Ms. Burnett, Ms. Bartlett, I'm sorry. You may proceed.
Do you want me to be sworn in or no?
I normally don't swear in
Okay,
attorneys. You
Okay.
are an officer
That's
of the
fine.
court, so you may proceed.
Thank you. My name is Carol Bartlett. Walter T. Hangy Sr. died on April 3rd, 2025 in Missouri City, Fort Bend County, Texas at the age of 91. 4 years have not elapsed since the date of his death. He was domiciled and had a fixed place of residence in Fort Bend County at the date of his death. His will dated June 21, 2016, which I am familiar with and prepared and witnessed his signature, purports to be his last will. It was never revoked as far as I know. It was, we produced an original document to the clerk of the court and asked the court to take judicial notice that this is the original document. The will was self-proved.
The court shall take judicial notice.
A necessity exists for the administration of this estate. No children were born to or adopted by Mr. Hangy after the date of the will. He was married twice. He divorced his first wife, Constance Hangy, in 1971. His second marriage to Betty Hangy ended in her death in 1996. No marriage was dissolved after the date of the will. His daughter, Maggie Hangy Nimri, is not disqualified by law from accepting letters testamentary or from serving as such. No state, governmental agency of a state or charitable organization is named in the will as a devisee. Your Honor, this is going to be a non-taxable estate, and we ask that you waive appraisers.
All right. Court heard the testimony of Carol J. Bartlett. She testified as to the proof of death, validity of the will, and other facts. The court will admit the will into probate and appoint Miss Margaret Constant Hangy Nimri as independent executor to serve without bond, and appraisers will be waived as well.
Thank you, Your Honor.
Anything further?
No, thank you. May I be excused?
Yes, you may. Have a good day.
Thank you. Takes me a minute. Always.
Bring in the attorney. Mr. Brown, good morning.
Good morning, sir. How are you?
I'm very good. Is your client with you?
Yes, it's my daughter, and she's sitting here next to me.
Oh, all right. Well, very good. Okay, well, let's get started. We're on the record in 25 CPR 042395, estate of Christopher Robert Ayers. All those who intend to testify, if you'd raise your right hand. Do you solemnly swear or affirm that the testimony you provide here today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Very good. Mr. Brown, whenever you're ready.
Okay, will you state your name for the court, please?
Lauren Brown Ayers,
And how you related to Christopher Robert Ayers?
widow, spouse.
Okay. Were you named as the independent executor under his will?
Yes,
Okay. Did Chris pass away on February 8th, 2025 in Fort Bend County?
yes,
Was he 44 at the time of his death?
yes.
Okay. 4 years have not elapsed since the date of his death, has it?
No.
Okay. Chris was domiciled in Fort Bend County at the date of his death,
Yes.
and the principal estate is located in Fort Bend County.
Yes.
Okay. The judge has put on the screen the last will and testament of Chris. Do you recognize that document?
Yes.
Okay. Is that Chris's signature at the end?
Yes, it is.
Okay. As far as you know, that will has never been revoked?
Correct.
And it's a true and correct copy of the original will?
Yes.
Okay. Chris was married at the time of his death?
Yes.
Okay. Were any marriages ever dissolved after the date of the will?
No.
Okay. Were any children born or adopted by you and Chris after the date of the will?
Yes.
And who were those children?
Dylan Ayers and Logan Ayers.
Okay. Are any governmental agencies or the state of Texas named as a beneficiary under the will?
No.
Okay. Is any charitable organizations named as a beneficiary under the will?
No.
Okay. And you're not disqualified by law from accepting letters of testamentary, are you?
No.
Are you requesting the court to authorize independent administration of the estate?
Yes.
Okay. Are you asking the court to waive the bond?
Yes.
Okay. Is there a need for an appointment of appraisers?
No.
Okay. Your Honor, we pass the witness.
All right, the court heard the testimony of Lauren Brown Ayers. She testified as to the proof of death, validity of the will, and other facts. The court will admit the will and to probate and appoint Ms. Ayers as independent executrix to serve without bond, and appraisers will be waived as well. Ms. Ayers, I'm very sorry for your loss. Mr. Brown, is there anything further for the record?
No, Your Honor, there's not. We will sign the proof of death and the oath and e-file it.
Very good. Everything should be signed by the court here shortly.
Okay, fine. Thank you, Your Honor.
All right, y'all have a good day.
Thank
Okay,
you. You too,
bye-bye.
sir.
One second, Annie. All right, go ahead and bring in the next.
Audio. Here's Nick.
Mr. Mayalaro,
Hello.
hello. Can you turn your camera on, please?
Trying to turn the video on.
There you go. Oh, it's not working.
You were on briefly a second ago.
There we go. Good morning.
Good morning. All right. Let's go ahead and get started. We're on the record in 25 CPR 042015, Estate of Geneva Reed Malaro. All those who intend to testify, if you'd raise your right hand to be sworn by the court. Each of you solemnly swear or affirm that the testimony you provide here today will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Very good. Mr. Corner, you may proceed. Sir, you're muted. You're going to need to unmute yourself.
Can you guys hear me?
Yes.
Thank you, Judge. Good morning, Bob. I'm just going to ask you a few questions. Your name is Robert A. Malaro, and
Milaro, yeah,
Malaro, and you are the husband of Geneva Reed Malaro, correct?
that's correct.
And Geneva died on November 30th, 2024 in Fort Bend County, Texas, at the age of 90, correct?
That's correct.
And 4 years have not elapsed since the date of her death and the filing of the application to probate the will as a muniment of title, correct?
That's correct.
And this court has jurisdiction and venue over the estate of Geneva Reed Mayaro, because Geneva was living in Fort Bend County at the time of her death, correct?
That's correct.
And she died with a will which was signed on July 18th, 2005, correct?
That's correct.
And you can see that on your screen right now?
Yes.
Yeah, the court's going to go ahead and scroll through it just so that you can look through there and just familiarize yourself real quick. Can you confirm that the witnesses to the will, Chip Evans and Nancy A. Gonzalez, were over the age of 14 at the time that they witnessed
Yes,
your
yes,
wife signed the will? Is that correct?
yes, yeah,
And to the best of your knowledge, this will was never revoked, correct?
correct. Yeah,
And no state governmental agency of this state, nor any charitable organization is named in the will as a beneficiary, correct?
correct. Yes,
And after July 18th, 2005, the date of the will, no child was born or adopted by Geneva, correct?
that's correct.
And Geneva did not receive Medicaid benefits on or after March 1st, 2005, correct?
That's correct.
And to the best of your knowledge, the proof required to probate the will as muniment of title has been met, correct?
Yes, correct.
Your Honor, I'd like to ask that the court admit the will to probate as a muniment of title.
All right, the court heard the testimony of Robert A. Maialaro. He testified as to the proof of death, validity of the will, and other facts. The court will admit the will into probate as a muniment of title, and I'll waive the affidavit of fulfillment of terms as well. Sir, I'm very sorry for your loss. All right, Mr. Corner, anything further for the record?
No, Your Honor. Thank you. Thank you for today. We appreciate it.
Y'all have a good day.
You too. Thank you.
Thank you.
Okay, Bob, we can leave the meeting now.
Okay,
And no one's called to say that they're filling in. Okay, then we'll move on to the next case after that. Merchant, correct? So we do not have the witnesses for this case in the waiting room. Would they happen to be with somebody?
Let me check and see. I think they might be with the applicant, Mr. Merchant.
Yeah, both witnesses are with me right now.
All right, then, we're on the record in 24 CPR 041846, the state of Abdul Hamid Merchant. All those who intend to testify, if you would raise your right hand to be sworn by the court. If I could have all the witnesses, yeah, there we go, perfect. Do each of you solemnly swear or affirm that the testimony you provide here today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Yes.
I do.
Yes.
Yes.
All right, Ms. Brooker, let's start with the airship first. Once we've concluded the airship, we'll move into the administration.
Okay, Your Honor. I'll start with the witnesses then. I will call Miss Den.
Yes.
Miss Den, will you state your full name for the court?
Bilkis Din.
And where do you reside?
Sorry,
Where do you live?
I am living in the Stafford.
Okay. And how did you know the decedent, Abdul Hamid Merchant?
I am Hamida Merchant is my friend, been 10 years, and I know Abdul Merchant too. I already know.
So,
Yeah.
so you were,
She's going to need to repeat that answer. My court reporter is having a hard time understanding her. Maybe if she could get a little bit closer to the microphone.
Yes, sir.
I'll ask the question one more time. How did you know the decedent, Abdul Hamid Merchant?
I knows them like been 10 years.
Okay. And were you a family friend?
Yes,
And you were aware that Mr. Merchant passed away on February 28th of 2022 at the age of 76. Is that correct?
yes, correct,
And he was married to Hamida Merchant, your friend, correct?
correct.
And you're aware that Mr. Merchant had 2 children born to him. Is that right?
Yes, correct.
And that would be Sean Merchant, the applicant, as well as his brother Neil Merchant. Is that right?
Yes, correct.
And did you know of the Mr. Merchant to bring any other child into his home to raise as if that child was his own?
No, ma'am.
Did you know of any adopted children?
No, ma'am.
And did you ever have any conversations with Mr. Merchant about preparing a will?
Yeah, I talked to her.
Mr. Merchant.
No.
And so to the best of your knowledge, he did not have a will. Is that correct?
Yes, correct.
And do you have a financial interest in Mr. Merchant's estate?
No,
Does the estate owe you any money?
no,
Do you owe the estate any money?
no,
Do you owe the
No.
estate any money? Okay.
No.
Are you being compensated for your testimony today? Are you being paid to give your testimony today?
no,
And have you ever been adjudicated as an incapacitated person?
no.
Thank you. I will pass this witness, Your Honor.
All right, Mr. Moore.
Your Honor, Ms. Den, my name is Carl Moore. I'm the attorney ad litem. Do you recall speaking to me? I think we're issued.
Yes.
Then you need to come back. I have that effect on people. Do you remember speaking to me?
I'm sorry?
On the phone. Did you
Do you remember speaking to me in January?
Yes,
And you told me that you were family friends with Abdul and Hamid, correct?
yes, correct.
And you told me that you would see them at church, is that correct?
Yes, correct.
And you told me that you knew them for 15 years. Do you remember that?
Yeah, almost 10 years. I know them.
And Hamida and Abdul had 2 sons, is that correct?
2 sons.
And that's Sean, who's sitting next to you, and Neil. Is that
Yes.
correct?
Mm-hmm.
There were no other children,
No,
no adopted children,
no, sir.
and they didn't bring any children into the house to be raised. Is that correct?
Yes, correct. No,
Thank you very much.
you will. Thank you.
Ms. Brooker, call your next witness.
Thank you, Your Honor. I will call Mr. Ali.
Yes, this is
I'm-
Ali. Mhm.
Hi, Mr. Ali. Will you state your full name for the court?
Barkat Ali.
And where do you live?
I live in Sugar Land, Texas.
And how did you know the decedent Abdul Merchant?
I know it's more than 25 years. They are a family friend. Through my son, they go to school, college, basketball, and they were child together.
So you've known him for a long time.
Oh yes, more than 25 years. Yeah.
And to the best of your knowledge, Mr. Merchant passed away on February 28th, 2022. Is that correct?
Yes, yes. Mhm.
And he was 76 years old when he passed. Is that right?
Yes. Mhm.
And did you know Mr. Merchant to be married at the time of his passing?
Yes,
And he was married to Hamida Merchant. Is that correct?
yes,
And did you know Mr. Merchant to have 2 children born to him during his lifetime?
yes,
And those 2 children would be Sean Merchant and Neil Merchant. Is that accurate?
yes. Mhm.
And did you know him to have any other children born to or adopted by him?
No,
Any other child that he brought into his home to raise as if they were his own child?
no,
And did you ever have any conversations with Mr. Merchant about preparing a will or having a will?
no.
And to the best of your knowledge, he did not have a will. Is that correct?
Yes. Mhm.
Do you have a financial interest in Mr. Merchant's estate?
No,
Does the estate owe you any money?
no,
Do you owe the estate any money?
no,
Are you being compensated for your testimony today?
no,
And have you ever been adjudicated as an incapacitated person?
no.
All right, Your Honor, I'll pass this witness.
Mr. Moore.
Charlie, good morning. My name's Carl Moore. We spoke back in January. Do you recall that?
Back in January,
Over the phone.
over the phone,
John gave me your phone number and I called you on January the 22nd. But I'm the attorney ad litem for the unknown heirs. And at that time, you told me that you'd known Abdul and Hamida for over 24 years. Is that correct?
yeah. Mhm.
And you said that you were social friends. Is that correct?
Yeah. Mhm.
And that your sons are in fact friends with Sean and Neil. Is that correct?
Yes.
And you believe that you are have a good knowledge of their family history,
Yes.
and there are no other children. Is that correct?
Yes. Mhm.
No adopted children?
Yes. No, no, no.
And they did not bring any children into the home to be raised. Is that correct?
Yes.
Thank you, Mr. Ali. I appreciate your time.
Ms. Brooker, anything further for the record on the airship?
I would just call the applicant.
Proceed.
Mr. Merchant, will you state your full name for the court?
Yeah, Sean Merchant
And where do you reside?
in Richmond, Texas.
And you are the one who filed the application for determination of heirship and for independent administration, correct?
Yes, correct.
And Mr. Merchant, Abdul Hamid Merchant was your dad, correct?
Yes.
And so you knew him pretty well.
Yeah. Yes.
Did you ever have any conversations with your dad about having a will?
Briefly, but we never moved forward on it.
And so after his passing, y'all went through his possessions. Did you find anything resembling a will?
We did not see anything.
Okay. And so you're here today because you believe your dad had no will. Is that correct?
Yes, that's correct.
And your dad passed away February 28th of 2022 at 76 years old. Is that right?
Yes, that's correct.
And he lived in Fort Bend County. Is that correct?
Yes, he did.
That's where his principal estate was situated, correct?
Yes.
And your dad your dad and mom were married for how long?
Over 40 something years. Yeah.
And their marriage essentially ended at his passing, correct?
Yes.
And you have one brother, Neil Merchant, is that correct?
Yes, younger brother, correct.
And do you know your dad to have any other children
No,
born to or adopted by him?
no.
And you feel like you would have known?
Yes, I would.
Okay.
Yeah.
And your dad didn't bring anybody into his home to raise as if they were his own, is that correct?
Yes, that's correct. No other kids.
All right. Those are all the questions I have for you on the airship piece. I'll pass the witness.
Thank you. Mr. Merchant, you and I have spoken several times, correct?
Yes, that's correct.
And exchanged several emails, is that correct?
Yes,
And do you believe that the heirs of your father's estate are your mother Hamida and you and your brother Neil?
yes, that's correct.
No other siblings, no other children, correct?
No other siblings, no other children, correct.
Thank you for your time, sir.
Ms. Brooker, anything further for the airship?
No, Your Honor.
After listening to testimony of Bilquez Den, Marquette Ali, and Sean Merchant, the court finds by clear and convincing evidence, Eden's heirs are those listed in the judgment declaring heirship. I'm going to discharge Mr. Moore from his duties as attorney ad litem and award him a fee in the amount of, is it $1,025? Is that correct?
Yes, Your Honor.
And is that agreed to, Ms. Brooker?
No objection.
All right. Mr. Moore, you're free to go. Thank you for your assistance. And then, Ms. Brooker, you may call your witness for the administration.
Thank
Thank
you,
you.
Your Honor.
Thank you, Mr. Moore.
Thank you. Nice to meet you.
Nice to meet you as well. I will call Mr. Merchant again. Mr. Merchant, just a few questions for you. You believe that your dad's assets are such that there is a need to administer his estate. Isn't that correct?
Yes, that's correct.
And you're asking the court to appoint you as the independent administrator of your dad's estate. Is that correct?
Yes, that's correct.
In fact, all of the heirs, your mother and your brother, have all said you're going to be the one to be the independent administrator of your dad's estate. Is that correct?
Yes, I'm the lucky one.
You're the lucky one, and they've all filed consents with the court. Is that your understanding?
Yes,
Do you believe you're able, and are you willing to serve as the independent administrator of your dad's estate?
yes, I'm willing and able.
And you believe you're qualified to serve?
Yes, I am qualified.
Okay, you testified you're a resident of Texas, correct?
Yes.
Have you ever been adjudicated as an incapacitated person?
No.
Are you a convicted felon?
No.
Ever been convicted of a crime of moral turpitude like fraud?
No.
All right, I'll pass the witness, Your Honor.
After listening to testimony of Sean Merchant, the court finds that the decedent died intestate and there's a necessity for administration. The court will grant the request of the applicant to appoint Sean Merchant as independent administrator of the estate to serve without bond. Mr. Merchant, I'm very sorry for your loss.
Thank you.
Ms. Brooker, anything further for the record?
No, Your Honor. Thank you so much for your time today.
All right. Thank you all. You'll have a good day.
Thank you.
Thank you. You too.
Thank you.
Bye.
Proceed with the next case, Kelly Renee Doubt. I think there's somebody else in the room. Mr. Dupree.
I'm here, Judge.
Okay. Are all the witnesses with you?
I have one witness here and one witness, Latham Waters there.
Latham Waters, okay. All right, then. Let's go ahead and get started. I think everybody's here. Mr. Waters, would you turn your camera on, please? Mr. Waters.
There you go.
We're on the record, 24 CPR 040579, estate of Kelly Renee. Is it Duaut? Duaut?
Yeah, do what?
Duaut, all right. All those who intend to testify, if you'd raise your right hand to be sworn by the court. Do each of you solemnly swear or affirm that the testimony provided here today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
All right, very good. You can lower your hands. And Mr. Dupree, we're going to start with the airship, and then we'll move into the administration once we've concluded the airship.
All right, thank you, Judge. I call Megan. Megan, can you state your name for the court?
My first name is Megan and my last name is Duat.
And how did you know the decedent Kelly Duat?
Kelly is my husband's half sister.
And about how long did you know her?
10 years, roughly.
Okay, so you had the opportunity to become familiar with her family and marital history during that time, is that correct?
Yes.
And to the best of your knowledge, she was never married during her life, is that correct?
Yes.
And she never talked to you about staying with someone or living with someone long-term that they intended to be their spouse or something like that?
Correct.
And to the best of your knowledge, no children were born to or adopted by her during her life, is that correct?
Yes.
She never talked to you about taking someone into their home or introduce someone as their son or daughter, is that correct?
Yes.
And you have no financial interest in this estate, is that correct?
Correct.
You're not getting anything for being here today, is that correct?
Correct.
Thank you. Pass the witness, Judge.
Mr. Novi.
Thank you, Judge. Megan, it's been a while, but I sent to you a airship ad litem questionnaire, which you're very nice to complete and send back to me. Is that correct?
Yes.
And just a few more quick questions. Kelly's father predeceased her, is that correct?
Correct.
But her mother, Jerry Lynn Waters, survived Kelly, is that correct?
Correct.
And could you explain the relationship of Ryan? I guess that's your husband. Could you explain his relationship to Kelly?
They are brother and sister, brother and half sister.
Okay. And do you happen to know if Kelly had a will by chance?
Kelly did have a will. Correct.
Okay. And in that will, there was an independent executor who was named, but he declined to serve in that position. Is that correct?
Correct.
Also, he also declined any inheritance rights or distribution in that will. Is that correct?
Correct.
And in fact, that's why we're having to have this heirship determination at this time. Is that correct?
Correct.
Okay. Judge, I pass this witness.
Call your next witness.
I call Cecil Waters. Cecil, can you state your full name for the court?
It's Cecil Lathan Waters, Jr.
And how did you know the decedent Kelly Duat?
She is the daughter of my wife, Jerry Lynn.
Okay. So you had, about how long did you know her?
Oh, approximately 15 years.
Okay. So you also had the opportunity to become familiar with her family and marital history, is that correct?
That's correct.
And to the best of your knowledge, she was never married during her life, is that correct?
That's correct.
And to the best of your knowledge, no children were born to or adopted by her during her life, is that correct?
That's also correct.
And she had one sibling, Ryan Duat, is that correct?
That's correct.
Her father predeceased her, is that correct?
Yes, that's correct.
You just mentioned your wife, Jerry Lynn, was her mother, is that correct?
Yes.
And you have no financial interest in this estate, is that correct?
Yes, I have no financial stake.
You're not getting anything for being here today, is that correct?
No, no.
Thank you. Pass the witness, Judge.
Novi.
Thank you, Judge. Cecil, again, I sent you a questionnaire and you were very kind enough to send that back to me with those answers. Is that correct?
Yes, that's correct.
And none of those answers have changed, obviously, since you sent that to me. Is that correct?
No, they have not.
All right. It's probably a very important question. Those fish behind you, were they ever alive?
No, they were not. Decorative only.
All right. Well, thank you for that information. So would be your testimony that Kelly's father predeceased her,
Yes.
but your wife was a surviving mother to Kelly,
Yes.
and that Ryan Mark Duat is a half brother to Kelly.
Yes.
All right. And do you happen to know if there was a will that was found?
I do not personally know of it, but I have been told that there was one. I haven't seen the will or anything like that.
Okay. All right. Judge, I pass this witness also.
Mr. Dupree, anything further for the airship?
Nothing further, Your Honor.
Okay, Mr. Novi, I don't see an order on file, but what are your fees in this matter?
I thought I had sent one in, but I will check again. It was $650, Judge.
Okay.
I will check on that and either resubmit it or confirm that it was received.
After listening to testimony of Cecil Lathan Waters and Megan Dowell, the court finds by clear and convincing evidence the decedent's heirs are those listed in the judgment declaring heirship. I'm going to discharge Mr. Novi from his duties as attorney ad litem and award him a fee in the amount of $650. Mr. Novi, you're free to go. Thank you for your assistance.
Thank you, Judge. Have a great day.
You do the same. Mr. Dupree, you may proceed with the prove up for the administration.
Thank you, Judge. I call Ryan Duat. Ryan, can you state your name for the court?
Yes, it's Ryan Mark Duat.
And Kelly was your sister, is that correct?
Yes, my half sister.
Is it true that she passed away on January 14th, 2024 at the age of 50 years old?
Yes.
And she was domiciled and residing in Fort Bend County, Texas on her date of her death, is that correct?
Yes.
And you just heard testimony. She did leave a will dated November 6, 2023, is that correct?
Yes.
But that will name Gary Emons as primary beneficiary and executor, is that correct?
That is correct.
That he has declined to serve as an executor and has disclaimed all financial interest in this estate, is that correct?
That is correct.
And the will does not name an alternate beneficiary or an alternate executor, is that correct?
That is correct.
But all of the heirs to the estate, yourself and Kelly's mother, have consented and agreed to you serving as independent administrator without bond, is that correct?
That is correct.
And to the best of your knowledge, you are not disqualified by law from accepting letters of administration or from serving as independent administrator, is that correct?
I am not disqualified. That is correct.
Okay, thank you. That's all we have on the administration, Judge.
After listening to testimony of Ryan Mark Dualt, the court finds that all the decedent died testate, his or her will did not name a person to serve as executor, or alternatively, although the decedent named an executor, said executor was unable or unwilling to serve, and necessity exists for administration. Thus, the court will grant the request the applicant appoint Ryan Mark Dualt as independent administrator of the estate. Mr. Dualt, I'm very sorry for your loss.
Thank you.
Anything further, Mr. Dupree?
No, Judge, may we be excused?
Yes, you may. Thank you. Okay, let's go back to the other case and see if they're here. Ms. Freudensprung, if you would turn your camera on, please. All right, we're on the record in 24 CPR 041751, estate of Maddie Nell Carrillo. All those who intend to testify, if you'd raise your right hand to be sworn by the court. Do you solemnly swear or affirm that the testimony you provide here today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Very good. Mr. Listman, whenever you're ready, you may proceed.
Thank you, Your Honor. It's good to see you again.
Good to see you.
All right. Ma'am, can you please identify yourself for the court?
Yes, my name is Lori Frudensprung, and I am Maddie Carrillo's daughter.
Okay. And when did Miss Carrillo pass away?
She passed away in 2016. She passed away. My dad just died, and I'm confusing the date of his death.
Well, let me help you. Then
Thank you.
Did she pass away on October 9th, 2016?
Yes, correct.
At the age of 73?
Yes, correct.
Okay.
My
Now,
dad passed away on March 9th, so I'm sorry, I was confused. They both died on the 9th.
That's okay.
Okay.
Not a problem. Now, you're seeking to admit her will as a monument of title, correct?
Yes.
And you're
Yes.
not in default for failing to present the will within 4 years of the probate. Is that correct?
What is that question? I'm sorry.
You didn't know that there was any need to probate your will within the first 4 years after her death.
That is correct. My dad and I were unaware of that there was a stipulation, a time limit on that. We were, yes, uneducated.
Okay. Now, your mother had a will dated March 30th, 1989. Is that correct?
Yes,
And as far as you're aware, that will was never revoked.
correct.
And that will is the same will that you provided to our firm to file on your behalf.
Correct.
Now, and on that will, on page 6, there is a signature of Maddie Carrillo. And as far as you know, that is her signature.
Correct.
And you would know her signature having been her daughter, correct?
Yes, absolutely. Plus, we worked together all our lives. I'm very familiar with her signature.
Okay. Were there any children born to or adopted by your mother after the date of this will in 1989?
No,
And after this date of 1989, did she get divorced or otherwise dissolve her marriage?
no,
All right. And are you aware that did she ever receive or apply for Medicaid benefits on or after March 1st, 2005?
no,
And are there any debts or any need for any other administration of this estate?
no, they're not. All of that was taken care of shortly after her passing.
So there's no debts owed by the decedent that you're aware of?
No, there are no debts owed.
Okay. And as I said before, you're seeking to admit this will as a admit this will to probate as a monument of title only.
Yes, let me back up just a moment. There is a mortgage that is in Maddie's name and my stepfather, Joe Carrillo's name. So when you say debt, there is a mortgage that her name is still on, which is the process that I'm trying to go through so that my stepdad's estate can sell the home. And so that, legally if her name is still on the title, then I assume that is the debt. And that's the process for which we're trying to, go through now.
All right, let me ask it this way. Then is it true that there are no debts owed by your mother that were not secured by the real property at the time of her death?
No, they're not.
Okay, all right. And you're asking the court to admit this will to probate as a monument of title only.
Yes,
Okay. And and your mother was a resident of the state of Texas when she died?
yes,
And was she a resident of the Fort Bend County at the time of her death?
yes, yes.
All right, Your Honor, that's all the questions that I have. We would ask that this will be admitted to probate as a monument of title only. And that the clerk record the will together with the minutes together with this application, the minutes of the court, to constitute sufficient legal authority to all persons purchasing and dealing with the decedent's estate. We've submitted a proof of death and other facts and an order admitting will to probate.
Okay. Mr. Listman, I have a question for you. Did your client possibly receive bad advice, or maybe did not locate the will within the 4 years? Because as you know, as well as I do, that just not knowing to probate it within 4 years, according to case law, is not sufficient to allow a will to be admitted as a muniment of title. So is there some possible other reasons of why your client failed to admit the will into probate within 4 years to probate it as a muniment of title?
All right, Ms. Spring, let me ask you this. During that 4-year period, did you talk to an attorney? Did you talk to anybody concerning the admission of or the need to probate the will?
My stepfather did speak to an attorney. I'm not sure the exact time frame. I did not attend the meeting. He did speak to an attorney in Fort Bend County. I believe they started the process. Again, I'm not sure exactly the time frame. It wasn't completed. I have since found that out. I'm not sure all of the reasons that it didn't get completed. I think there were some issues on both sides. But you know, I'm not really sure of the extenuating circumstances for it not getting completed. I found out a lot of this after my father's death, that when we went to sell the property, that there was a case that had been opened but not completed and not finalized.
And that was a other earlier case to probate this will, correct?
Yes, I think it was 5 years ago or so. Yes.
Okay. All right.
I just want to clarify something. Ms. Freudensprung, do you mean when you say open, do you mean that the case was filed with the court, or just he had begun some sort of process? You weren't quite clear what he had done at that point, though.
Yes, Your Honor. I believe my father sat down with an attorney in Fort Bend County, and I was under the understanding that they were having dialogue, and that I was unaware that the will had been submitted. My dad was in his 80s. What he told me at the time was that he was was talking to an attorney, but I didn't get the answer as to where they were, but I just was very unaware of the status. But I know he talked to someone. I didn't know that anything had been filed with the court until after my father's death.
And Your Honor, there was a previous case concerning this will that my understanding has been non-suited to address that specific issue. So, and I don't have the information right in front of me. If you give me a minute, I can probably pull it up. But there was a previous case that was filed on this matter.
What I'm gathering from Ms. Freudensprung's testimony is she assumed her Stepfather had taken care of everything, that it was resolved. And when he passed, she discovered it was not. So that is a proper reason of why it was not admitted within 4 years. So that being said, the court heard testimony of Lori Michelle Freudensprung. She testified as to the proof of death, validity of the will, and other facts. The court finds that Ms. Freudensprung is not in default for failing to offer the will for probate within 4 years of decedent's death. Thus, the court will admit the will into probate as a muniment of title, and the affidavit of fulfillment of terms, however, will be required in this case. Okay, Mr. Listman?
Yes, understood. We will get that affidavit to you.
Ms. Freudensprung, first off, I'm sorry for your losses at this point in
Thank you.
time.
Thank
Both.
you.
Hopefully this can all get wrapped up and taken care of quickly for you so you don't have to deal with this too long.
I appreciate it. I do have one question for you, Judge, because this is way out of my wheelhouse. This is the first time I've ever hired an attorney or gone through probate. What is the time frame after Mr. Listman and I complete the paperwork that we need to complete, that the title would be clear so that I could move forward with selling this property?
Let me stop you there. I'm going to sign off on everything today.
Okay.
He'll submit some additional documentation, and then you should be able to obtain everything you need to go ahead and proceed with the sale after that. So in 24 to 48 hours after today, depending on how quickly Mr. Listman gets everything filed, you should be able to proceed with the sale.
Okay. I appreciate your time today, Judge.
Not a problem, Ms. Freudensprung. You have a great day.
Thank you.
Thank you.
Thank you.
Bring the next one. All right, can everybody hear me?
Yes, Your Honor.
All right, we're on the record. 21 CPR 035829, estate of Benjamin Okenye Okigbo. Ms. Kelly, we're here on a motion to release funds to the dependent administrator. Why don't you go ahead and proceed with your motion?
Yes, Your Honor. Our client received a $100,000 check payable to the estate of Benjamin. And at that time, she had not qualified as the dependent administrator. So those funds, her former attorney asked that those funds be placed in the registry of the court, which is this court ordered. Since then, my client has been appointed the dependent administrator and currently serves in that position. And we would ask that the court sign an order for those funds to be released to my client payable to the estate of Benjamin Okigbo.
And those funds will be used to pay debts or whatever needs to be
Debts.
administered.
Yes, and the further administration of the estate.
All right, what I'm going to do is I'll release the funds to her. She's still a dependent administrator, so she'll have to get with the court, let me know what's going on with the estate for the distribution of those funds elsewhere. But outside of that, I'll go ahead and grant those. They'll be moved from the registry of the court to the estate.
Okay, thank you, Your Honor. I'll get an order on file.
Sounds good.
Okay, I'll send you an order.
Thank you.
All right, thank you.
Have a good day.
Thank you.